Hello, everybody. This is Gary Berger. Uh, Hello, everybody. This is Gary Berger. I'm with Berger Law, and I'm doing our new revamped, changed date Facebook Live show, Ask a Lawyer. Now, we have, sorry if I hiccuped at the beginning, I'm doing it in a new situation in our office. As you can see, um, we are back in our office in beautiful downtown St. Louis. I will show you the camera out my window. You can see the Mississippi River out there if you look close enough. And we started remanning our office about 2 weeks ago. People are coming in staggered shifts. Some people coming in a couple days, other people coming in a couple days. I've worked 3 days in a row this week, but that's okay. I'm heading over to on a little vacation next week with my family. So next week's Ask a Lawyer will be remote. And we're changing the time. We're doing a couple things. We're changing things up. One is we're changing our days from Fridays to Wednesday afternoons. We thought that might be easier for people to tune in. The second thing is we're changing up our giveaways, our weekly giveaways as well. So let's move on to some of the questions that I had stacked up for people to ask me. One of the things that I got asked today from my friends is that it's today's July 1st. Half the year is over, and what have you accomplished this year? What has you as a firm has accomplished this year? So if this is not one of the craziest first 6 months in our history, I don't know what is. The coronavirus, the attacks and killings of George Floyd and other African Americans, prompting the Black Lives Matter protests. We're in a political election year, which is crazy. What is this? It's a crazy year. What's the rest of the year going to be? And the news on this corona is changing all the time. So we're reopened our office. We're here in staggered shifts. We're wearing masks. We're doing our social distancing. But it is certainly an interesting time. I'm doing a trip with my family and my parents. We're driving, not staying in any hotels, doing anything like that. We are simply trying not to touch anything. It's weird to go on vacations and trips this summer. This would be a time of the year I would look forward to. One of the other things that hit the news really hard this week is an experience with another lawyer, Mark McCloskey, and his wife brandishing weapons and threatening a Black Lives Matter protest that was going through their neighborhood. There has been a lot, the memes on this are crazy on social media, as well as the attention. And I understand Mr. McCloskey is on Anderson Cooper and is on Fox News and doing all these things, and he is certainly taking this and running with it, and getting as much press as I guess he can on it. I'm not saying it was planned or anything, but one of the theories on something like this is that if you get in the press for something embarrassing to you or your your business, you shorten the time window in which it is in the news by just kind of maybe making a couple comments and then kind of being done with it. That is not the case with Mr. McCloskey. He is certainly extending the window of time of the exposure that this story has gotten, and that's certainly his druthers, certainly his choice. So now the questions I get from that, though, is because I've talked about these protests and the rights and people's civil rights and these Black Lives Matter protests. His point, I think, is that this was a private subdivision. It's not public, and people broke down a gate and went through it. I don't know if but brandishing a AR-15 and having your wife on the trigger of a handgun, a Walther, is the appropriate response. I've owned pistols and I've taken CCR classes before, and my recollection of the education that I've gotten in gun use is you don't pull out a gun unless you're ready to use it. And in fact, much of the good CCR training, concealed carry training, is to how to diffuse situations, not how to inflame them. So that was interesting to me, that their choice to inflame those situations, inflame that rather than maybe sit on your porch, wave to the protesters, give them a bottle of water. I know other people in that neighborhood who did those things, and you certainly see what brandishing a weapon like that gets. And then another friend of mine who's a lawyer in St. Louis, not any relation to the McCloskeys, was featured in a column this week with Tony Messenger. His client was treated very differently, arrested, put in jail for doing a similar thing that McCloskey did. And I think Mr. Messenger's column wondered if people are being treated differently because of their race. McCloskey's white. My friend Brett Rich, who's a good lawyer in St. Louis area, his client was, I believe, African American. So those are the issues that are raised, and those are the questions that people have been asking me for that. Then the question becomes, and this is, as you know, is this Ask a Lawyer show, and I quoted the statute, is did the McCloskeys break the law? Now I'm not a prosecutor, so maybe I should shut up now, but it'll be interesting to see whether they are charged. We know that the St. Louis city prosecutor has been very politically involved with the Governor Greitens prosecution and some of her positions in that. Then she's been sued, and that created a lot of firestorm of controversy with Mr. Greitens, former Governor Greitens, who actually I guess is going to run for election sometime again. So that's in the news like in the last 2 weeks. It's a crazy year, as I said. So the statute at issue, if you've seen it on the internet, is section 571.030 of brandishing a weapon. And it says it is a crime when a person exhibits in the presence of one or more persons any weapons readily capable of lethal use in an angry or threatening manner. And the person commits the offense of unlawful use of weapons when they do that, and it's a Class E felony. So it'll be interesting whether the McCloskeys are charged under that statute or any other law. Certainly they had their weapon out. Was it capable of being used in a lethal manner? Well, Mrs. McCloskey had her finger on the trigger. Mr. McCloskey was pointing it at different places. She was pointing at different places. If it was loaded, I guess so. It was capable of a lethal use. I don't think you brandish unloaded weapons, certainly not in any class or any firearms training I'd ever heard of. But then again, you don't pull it out and do that unless you're going to use it, and they were clearly not going to use it. And in an angry or threatening manner, that's for them to decide. Now, do they have the right to protect their property, as they've been saying, from some imminent threat? That's what their position is. They've come out saying they're Black Lives Matter supporters, and that they had a real an emergent sense of a threat to them. But I don't know if that continued. I mean, these protesters kept walking and kept going down the street, and then went to the mayor's house to do a peaceful protest, and so that's their position, obviously. I don't know the answer to that. I'd be interested to see what Kim Gardner does in terms of charging them, and and they will certainly use that. They would use a criminal charge to continue to be in the press and make this an issue. I think this is different than the stand your ground laws. You have a right to protect your home from a home invasion or from a serious attack. Now, I don't know about a parade next to your house is a serious attack. But that's where the lines become fudged a little bit, because there are many good people in these protests, and marchers and families were there and kids. Sometimes there are people in those crowds that end up throwing rocks or doing stuff to property, and maybe later tonight they kind of do that too. More they can get out of control. I didn't see evidence that this was. So those are just some thoughts on the criminal law. It sounds from the letter of the statute that it sounds to me like they did that. Now, there's also the de jure versus de facto. What's in the law versus what's really done. So I don't know what the common practice in the city prosecutor's office or different prosecutors' office for prosecuting those types of crimes. The city prosecutor's office is very busy, and then we wouldn't want any special treatment from the McCloskeys one way or the other. If you have any other questions about that, put them up in the comment section of our live show. I have a lot of questions I'm going to turn to as well. Michael Ivans, hello, how are you? Michael asked me, is there any word on the MDOC overtime lawsuit Supreme Court ruling? Michael, the answer is no. There is no ruling on that, or no indication of a ruling. It's pending before the Missouri Supreme Court, and we have not had a ruling on that yet. My friend David Cly asked me, what is something that you know now as a seasoned attorney that you wish you would have known when you first started? Well, that's a great question. So I've been a lawyer for 28 years. And I've taught, David, it's the same thing. I think you posted the last time on the show is the Serenity Prayer. So, when you're a puppy lawyer, you can fight the facts and fight the circumstances of the case rather than just surrendering to what the facts are and figuring out other things to do with the case. So I know when I first started, I had more stress and anxiety with, man, I wish my case was a little bit different, or if this fact was this way, or if this person testified to this way, or can't get this person to testify this way. And as I have matured as a lawyer, it is what it is. And I will take this, and you know that I like this saying because I had a client, I'm reaching into my, here, I'll show you. I am now reaching into my, and you can tell in my bookcase, I have the sign that one of my clients made for me that says it is what it is, because it is what it is. These cases are what they are. People testified to what they do. I did a deposition yesterday of a person in a nursing home case where she's the only person alive who saw my client fall. She didn't remember anything. She kept saying, I didn't know. I was like, I didn't remember anything. I was like, did she fall from this lift onto the ground? I don't remember. I don't know. Were you looking? I may have been looking away. Well, you said you were holding her, trying to break her fall. How would you maybe try to break her fall and then you were looking the other way? How that's irreconcilable. Can you reconcile that? No. So it was crazy. And so when you have situations like that, and I have that in depositions all the time. So when you're deposing someone, when you're doing that and someone says they don't know or they don't go with you or that kind of stuff, there's a lot of things that I train lawyers to do or that I've learned to do myself about how to handle those different situations. And there's a lot of different techniques you can do. I mean, the question is a jury going to believe that? Her testimony? And I don't want to talk about the case anymore. I don't want in case a juror would watch this later, I don't want to influence anything, but I have all the time where deponents say crazy things like, I didn't do anything wrong. What do you mean? You rear-ended my client going 60 miles an hour. My client was stopped for 2 hours on the roadway. You didn't do anything wrong. But you do things like you say, well, listen, so you didn't do anything wrong in that scenario. You're not going to take any responsibility on it, right? Yeah. And then you say, and you're going to drive that way when you leave this courthouse, right? And you're going to keep driving that way, right? And then that's the point to the jury is that unless, and that's why the jury is here. That's why they're needed. Our jury system is to make people take responsibility when they won't. And so the jury needs to know is that if you don't, render a verdict, and a significant verdict, for the unnecessary harm done by this rule violator, this rule breaker, then they're going to keep doing that. You need to teach them a lesson, because if they walk away without a verdict or some significant recovery in the case, they're going to keep doing that, and then it's going to be your family and your kids who are the next one in line for that. So that's one of the things you do with a situation like that. With a situation of someone who doesn't remember something, like I ran into in this deposition yesterday by Zoom, there's a lot of things you do. So you do things. I said to her, I said, is this unusual for? I said, was this significant to you? And she wouldn't answer that. But then I said, was this unusual? And I said, I mean, have you ever had someone who fell to the ground and broke their leg and had to have it amputated? That's pretty. No, I've never had. So it's pretty significant. Yeah. The only time this has ever happened. Yeah. Something you would remember, right? Yeah. So do you remember it? Nope. It all happened too fast. It's all a blur. So, you can't, as a lawyer, you have to just surrender to those answers. You have to let them be, let it be. It is what it is. And then the question is, what does that answer mean? Where do you take it for the next step? And one of the tricks of a lawyer, and I know I'm talking about this maybe too long, is, so what lawyers do is they sit and they look at their list. They look at their questions. They read their question. The real trick of being a good trial lawyer, and I do this in my podcast. We have a podcast we do called Lawyer versus Lawyer, or me and another lawyer named Debbie Champion. We talk and teach lawyers how to be lawyers. You can go to the website, burgerlaw.com, look up the Lawyer v. Lawyer podcast. We talk and train lawyers about that. The best questions you can ask as a lawyer is when you're not looking at your paper. It's when you're sitting, your ears up, you're thinking, well, wait a minute, they answered that question. What's the next? They answered the question like that. What's the next question I should ask? It may not be in my outline because I never expected that, but what does that mean? So there you go. So relax and listen to it. And then, Dave, the other good thing that I learned, well, that's basically it. Let me move on to another question. I don't want to turn this into a deposition CLE. If anybody wants to listen to, so we did a CLE, which is a continuing legal education class last week. And let me ask the next question. What do you do with liens in a case? How do you negotiate and resolve liens in a case? Because in any injury case, what is a lien? It's a claim in a case held by an outside person. So you'll have a health insurance company like Anthem or GH or United Healthcare, UHC, who paid for medical care and now that wants their money out of the case. You'll have a medical provider like a doctor, hospital, ER, ambulance, air flight, physical therapist. They want to get paid out of the case because you didn't have any health insurance. The injured person did not have any health insurance, or because those people didn't get paid enough by the health insurance company. Or the other kinds of liens you could have an attorney's lien in a case. You can have a Medicaid or a Medicare lien in a case. So there's always a lot of liens in a personal injury case. And it's really important for me as a personal injury lawyer to not only get as much money as I can from the defendant in a case, but also to minimize the payouts on the back end. Minimize the payouts that you pay to all the lien holders, which is a trick, which is really a trick to do. So we do that, and I tell all my clients, not only am I going to get you as much money as I can on the front end from the defendant, but I'm going to minimize the payouts to the lien holders on the back end. The point of this, and so that's what liens are, and there's a lot of tricks that I do, or a lot of not tricks, bad word, a lot of techniques that I do to try to minimize the penalty and get as much money in my clients' pockets as I can. We did all those, and we did all those in a CLE the other day, which is a continuing legal education class, in which we did that. And while I'm talking, if Dave doesn't, they just put up the podcast episode. If you guys are, hey Davey, put up the whoever did that, Burger Law did, put up the under resources. If you go to, wait a minute, I'm not finding it. If you go to, so I have all my CLEs on my lawyer to lawyer thing. I have Control C. I'm going to do this comment myself. Control V. Oh, so what I just did was I almost ended this live video. I clicked the wrong thing. That will teach me from doing my own stuff. So they just put it on, but I put my lawyer to lawyer thing. If you go here and you go to CLEs at the bottom, if you go to my June 19th, 2020 CLE, you'll see all the presentation, my lien presentation, the appendix, liens and how to resolve them, ERISA liens and what that means. So, and if you want to get in the weeds, and we did that for about 100 lawyers a couple Fridays ago, and we also did a great ethics CLE, love and lawyering in the time of the coronavirus. And if you want more answers to get into details, if you're a lawyer watching this, we have great stuff on how to effectively handle and resolve liens in a case, which is something we encounter in every personal injury case. Not only are we fighting to get the money in the first instance, but we're also fighting all the lien holders, the health insurance companies, the providers, and that kind of stuff. Now, it's not that those people don't have a legal right to recover. Sometimes they do, but you got to know when they do and when they don't. And it's not like the doctors didn't provide great service to our clients. They did. There's a lot of great lawyers. There's a lot of great doctors, excuse me. There's a lot of great doctors and nurses and physical therapists and chiropractors and x-ray techs and radiologists who ought to get paid really well for the great work that they do. And we want to do that. And I pay a lot of doctors, and we pay, when we settle cases, we pay out a lot of healthcare providers because those people work really hard. They're really dedicated people. They're on the front lines with the coronavirus now. So we want to get them paid, and we work hand in hand with them. However, we don't want to get them overpaid, and it does come out of our clients' pocket. So the doctors should get paid fairly, but not unfairly, and they shouldn't get paid too much. And we really don't have a problem with that. We very rarely have to go with motions in court to fight it. We very rarely have to join that battle, so to speak. But we know what the rules are and what the guidelines are about what's fair payment, and we try to make it fair for everybody. And we're really effective in doing that. And if you want to see the video of our CLE or see any other stuff, it's in that section of the website. That's a long answer to that question. Let me go through and answer more questions. Brennan asks, if I run into one of those big concrete balls, those traffic things that's near me in Soulard and Down Shaw, is that a city problem or a me problem? That's a you problem, Brennan, because so those are, and I have them all around. I mean, my parents live over by Tower Grove Park, and I see them. And what they're doing, there's these balls that constrain the flow of traffic, so you got to slow down going through, because everybody knows what the St. Louis stop is. That's where you don't stop at a stop sign. And so when you go through on Compton or on Arkansas or Arsenal or one of those streets, if you're going through and you're blowing the stop signs, that's dangerous because there's kids there. There's people crossing the street. My parents live there. And they're not, as spring chickeny as they used to be. So those are to constrain traffic, and they're good, and they're safety devices just like any other safety devices. And if you run into one of them, it's your fault. It's an open and obvious condition. In order to make a claim for a dangerous condition of property, you cannot have seen it in the first place, and you can see those things. It's not just a defense. It's part of your prima facie case in doing that. And I hope you haven't hit one of those. And you know what? If you hit one of them, I bet you the city can sue you for damage to their property. So that's a you problem. I answered Michael's questions. I answered David's questions. Michael asked, Missouri State Statute for Protection of Property and Vehicle. Michael, I don't know that statute right off the top of my head, but it may already been answered. Mickey asked, the state of the Missouri overtime lawsuit. Guess we should forget about it, huh? Don't forget about it, Mickey. I'm going to fight this till the end. The case is pending before the Missouri Supreme Court. I already mentioned that, and that we hope for a great ruling. We hope for a ruling affirming the judgment below, and we're optimistic. My friend Danielle asks, my friend manages a business that is shorthanded during the pandemic. Are there legal repercussions to working off the books for a bit while helping them out? Well, I mean, look, there's the law, and there's the what really goes on, and there is, people work for cash. They do in this world, right? And if you're out of work and you're trying to feed your family, I'm not going to tell you not to go work for them. And if the business needs some help, that's that happens. Now, I will also say it depends on what you mean working off the books. I'm a lawyer, and I'm bound to obey the law. I'm not going to tell you not to report that on your taxes, but you can work for cash and put it on a 1099. And and the business, you don't want to. I've run a business for 20 plus years, my law firm, and I worked ever since I was 14 and stuff. So there are shortcuts that businesses that can take, but the shortcuts are never worth it. There's always a softer, easier way, people think. But if you're going to sit there and not do W-2s or not pay taxes or work for cash and not do that, you shouldn't do that. Bite the bullet, pay the taxes now, be a responsible citizen. You're paying for our roads. You're paying into your Social Security later. You're paying taxes so that we can run our government, and then you're being a citizen. I mean, you can dodge that. But should you dodge it, or should you stand up and be responsible? So the repercussions are, if you are working and you're not paying taxes, you're committing IRS fraud, you're ripping off the government, that's a crime. If you're hurt, if you're working on off the books and you're hurt, you're not going to be covered. You may not be covered by work comp. Work comp laws would protect you from an injury. So those are the things I would caution against. You want to be part of the system. There you go. I think I answered that, Danielle. Michael says that you can only protect your property if you have an imminent threat of life and death. That may be true. And I can look that up. I'm going to read through some more comments, and I may come back to that because I already talked a lot about that. Davey asks, how do evictions work during this pandemic? Are landlords able to start the legal process now, or do they have to wait until the pandemic is over? Great question. It looks like I just put up the Missouri self-defense laws are in the comments. I didn't see that. I didn't scroll down. Thanks, David, for putting that on. I really appreciate it, David. Thank you for your support. So there you go. Click on that link, everybody, in the comments to this for the Missouri self-defense laws. And then there's a link there to the video for liens on injury cases and resolving them, which is my recorded Zoom speech. It'll look a lot like this. Well, I don't know if I did wear a bow tie on that one. And my hair is this is still the number 6 for anybody who likes my hair. I think I got to give another haircut to myself here soon. Maybe I should film that. Let me get to another question. Imminent threat of life and death. Hey, Michael, I know I knew who you were tagging, Michael. I get it. Oh, let me get this. So there was a really good question by Davey, and so what are they doing with evictions? Well, they weren't doing anything. So what happened was the courts were closed. So there was a moratorium on evictions for a while. And I'm going to share this article because I'm going to do this. I'm going to show you that I can do it. Control A, Control C. So for a while there was a moratorium on on evictions. And I just shared that article. And then what happened was they reopened the courts and they were flooded. I'm going to share another article with you right now on a flood of evictions. And the city sheriff's department was getting ready because they knew there was going to be a lot of orders trying to kick people out. The sheriff's department, knew they needed to go serve a bunch of people because the court, you can't evict anybody, and people aren't making money. They can't pay their rent, but the landlords want to evict them, but they can't. So frankly, what the landlords should do is the landlords ought to work this out. The landlords ought to work it out with their tenants because most tenants I know, they want to pay, but if they can't, then the landlord will make more money keeping a good tenant who's not going to rip up their stuff and then maybe forgive rent for a couple months or two. Now, my landlord didn't. My landlord is tough, man. He did not, but that's okay. We're working hard. We can pay him. So the courts closed. You couldn't do the evictions, but now the courts are open, and these evictions are going to come like crazy, and it can be really tough on people. I'm on the board of Legal Services of Eastern Missouri. I know SLU has a clinic. I know other lawyers do a lot of volunteer pro bono time to try to keep people in their houses. You have some great landlords that look out for the people. You also have landlords that are bad, like anywhere else, and are unscrupulous, and they'll try to rip people off and then add on costs and all that stuff, add on damage deposits, add on attorney's fees and stuff. So I've done a number of videos for Legal Services of St. Louis, Missouri about your rights. I did videos for them about your rights for evictions, LSEM evictions. So I'm going to look that up right now. Legal Services of Eastern Missouri has a housing law program that I'll put up and they have a, this is great. What are your tenants' rights for COVID-19? So here's Control C. I'm going to put this up here too. Control V, enter. So this article right now will give you everything you wanted to know about some of your rights under COVID-19 from Legal Services of Eastern Missouri on evictions. One of the great things, so like this CLE we did, all the proceeds went to Legal Services. Legal Services of Eastern Missouri has been around for a long time. I'm flattered to serve on the board of directors there. LSEM has all kinds of stuff. They have rent relief letters that they will send for you. They have lawyers. If you meet their qualifications, I'll put that in the comments. If you meet their qualifications, they will represent you for free. And it's basically, if you're making it 150% level of poverty, or what's considered by poverty by the federal government, then you can do that. Then you can get free legal representation by them. I've shared a couple things for them from their page, but there is a housing law program that they have tons of free information at that I am now sharing with you on the comments to this as well. Evictions are happening. They're going to happen. Courts order them. I've sat in some of those dockets sometimes where I think it's terrible that the government is in the business. The court systems are in the business of doing that, but that's the way it works. I also don't like that the court systems are in this business being debt collectors for big credit card companies. And I have some old, on the website, I've done some different columns and writings on the inequity of that. I volunteer my time to try to balance the scales of justice, because people don't know what their rights are. But go to some of these links that I put in the comments to this from Legal Services, and that's where you get further detailed good information about evictions and your rights under those laws. So now let me move to new questions. I got Davey's question. And the second half of this, or do they have to wait until the pandemic is over? The courts are opened. So the pandemic is not over, but the courts being closed for the pandemic are over. I have friends who are judges who are doing these Zoom hearings with large amounts of people on their Zoom dockets, and they're kicking people out. I had a judge friend of mine told me the other day, he said, yeah, there's a guy on Zoom, and you could tell he's driving and on Zoom on his phone, and the judge had to go, listen, pull over the side of the road. You can't Zoom and be in court and be driving at the same time. So one of the crazy things about the pandemic are the type of stuff we all have to handle, the types of problems we did not think we were going to have to handle and do. One of the things we're doing here is trying to do this Ask a Lawyer program to try to answer people's questions. I got some nice comments from Adam. Thank you. Thank you, Michael. Thank you, David. Thank you, Maya. Maya asks, can an employer fire an employee for Missouri for no good reason? Can you explain at-will employment? Yes. An employer, now I'm about to say a bad word, so you got to tune in. An employer can fire you for a good reason, a bad reason, no reason at all, or a mistake. I'm getting to the bad word. Hold on. So like you can, and a mistake. So your employer can think that you took money out of the cash register. He can fire you. She can fire you. The next day they can figure out, oh, the $100 bill was under the drawer. We missed it. You didn't steal money. You're good to go. They don't have to hire you back. They can keep you fired. So, or a mistake. They can fire you for a good reason, or no reason, or bad reason, or no reason at all. And it's not, here it comes, it's not illegal to be an asshole as a boss, okay? You can be a jerk as a boss. That's not illegal. Now, the only things that you have, the only protections you have are, if you're a member of a union where you have a contract for employment and you have appeal rights, but you also can't fire someone for being black or old or a woman, or you can't sexually harass people, and as of 2 weeks ago, for being gay or lesbian or LGBTQ, and which is a great decision out of the United States Supreme Court. Now, that decision only applied to federal anti-discrimination laws. So, under the state law, you can, we have these different jurisdictions. State law, you can, it's employment at will. Good reason, bad reason, no reason at all. You can fire them or mistake. But Missouri has a anti-discrimination law, and the federal government, and there's a federal anti-discrimination law that protects discrimination in employment. You can't fire someone for pregnancy, the Pregnancy Discrimination Act. You can't fire someone for being old, the Older Workers Benefit Protection Act. So all of those laws augmented the ADEA, Age Discrimination, the ADA, Anti-Disability Act, Age Discrimination in Employment Act, ADEA. So there are federal and state laws. And so if you're fired from a job and it's not because of discrimination, go get another job and go for unemployment. If you think that you were fired because of discrimination, sex, age, race, sexual orientation, you have 180 days to file a charge of discrimination with the Missouri Commission on Human Rights or the Equal Employment Opportunity Commission. And that's it's at Spruce Street, 1222 Spruce Street. And then you go file don't just do the intake. You got an intake questionnaire. You have to file an actual charge of discrimination. I do some employment law. I've done it for years and years and years. I don't do as much. I always have some cases going on. Oh, here's another thing you can't do. I forgot. So in your example, Maya, if you have a workers' compensation claim and you're injured on the job, you hurt your back lifting something, or you get your finger cut off or something, and the next day you work there forever, and the next day your employer fires you, or the day after you file your work comp claim, they fire you, you have a retaliation claim for exercising your rights under the workers' compensation law. So there are laws to protect that as well. There may be other nuanced laws. Remember that we answer all questions for free at Burger Law. So if you have an employment law question, call us. We'll answer your question. If it's something that we can't legally represent you in, we have a lot of friends who do this work. And we have friends who are some of the best employment discrimination lawyers in the city and in our area, in Illinois, Missouri, and anywhere. So that's the law on employment at will. You can have a contract of employment. So if, let's say, though, that your employer gives you a contract. I agree to employ you for a year. Here's your salary. So let's say you live in New York, and someone says, I want to bring you to St. Louis and hire you here. You may say, listen, I'm going to spend all this money moving here and buying a new house. Give me a contract for a year so I know I ain't going to move here and get fired the next day, which can happen. There are cases about that. So you can have a contract for employment, and a union agreement, a union contract is such a contract. There are also sometimes protections for employment, like if you work for the city of St. Louis, you may have civil service protection, or there are other protections for employment. But remember, just because you have an employment manual or employment or policy manual or employee handbook does not remove you from the employment at will statute. That's the case is called Johnson. There's a lot of cases on this issue. It's a highly litigated issue. It's tough to win that because all of the employment manuals say this does not change your employment at will status. Now, I did have a case, the Department of Corrections case, that everybody's asking about, a number of people are asking about in this. We won on a breach of contract case because in that case, the state of Missouri promised in a contract to abide by and comply with the Fair Labor Standards Act and the accrual and payment of overtime. They also had other policies in place where they agreed to pay employees for the time they physically work, or they agreed to comply with the FLSA, or they agreed to comply with the Missouri minimum wage law. And what those laws say is you have to pay people while they work. You have to pay people for pre and post shift activity, we believe. And while they're doing activities that are integral and indispensable to their work, like guarding while you're going through security. And we won that case because that was a contract entered into, signed by the state and its employees, and there were other policies and provisions on which both the employees and the employer relied that were a contract. And that case wasn't an employment at will case, had nothing to do with it, because I wasn't saying that you couldn't fire someone. My clients were not saying you couldn't fire someone. My clients were not saying we want to be employed in the future. What they were saying is that we had an agreement for the past, and you told us in writing a number of places you were going to pay us for this pre and post shift activity in the past, and you didn't, and you ripped us off, and we want to be paid a fair wage. It's not like corrections officers are overpaid. We're like 48th in the nation or something. I mean, the corrections officers are some of the hardest working people, and they're really doing a service to us by keeping the bad people in jail. So those are some issues surrounding employment at will, and I probably over-answered it, but you know, it's an interesting issue. Let me go to some more questions. I'm going to go to the bottom to make sure I'm not missing anything. Jeff, my friend Jeff Stussy. Jeff, how are you? Jeff and I have different political views, as he and I knows, but we mostly play fair. Sometimes we don't, but we mostly do. But Jeff's beautiful wife and I went to high school together many decades ago, and she's great. She certainly is your better half, Jeff. You certainly outkicked your coverage in that. And I think you would agree with me. Too bad I can't see you at baseball games. I used to love to see you guys every few games. Jeff asked me, is Missouri a stop and ID state, or does officer need reasonable suspicion to ID you? Is ID mandatory on request? He has to have reasonable suspicion to ID you. So the answer is yes, I believe. Remember, New York had that stop and frisk law that Mayor Bloomberg enforced, and that was all hot. That was all addressed in when Bloomberg was running for president, and they had authority at that time under a local ordinance in New York to stop and frisk people and had reasonable suspicion. So yeah, they need reasonable suspicion to ID you. But I mean, it doesn't take much. I mean, Jeff, if you're outside at a bar causing trouble at 2 a.m., they're going to say, hey, what are you doing? Let me see some ID and make sure you're legit. Make sure you're not doing that. And we know cops did that when your wife and I were young. Cops would roust us and ask for ID when we were having parties and that kind of stuff. And it's a way to keep track of people. And you never know what you're going to get. You know, officers have a tough time. Officers have a tough job. I was reading other questions. Sorry. Officers have a tough job. So where's the line about appropriately IDing someone who you think may be up to no good versus just being a jerk and trying to dissuade people from doing what they should be doing? It's a tough line, and you know, and obviously the person who thinks they should be there and have a lawful right to be there, like the McCloskeys. They think, I mean, could a cop come up and ID them because they're holding a damn AR-15? I think they should. Lord, who does that? That's crazy. It's crazy. But I think they could. So that's it. But Jeff, I'm not as much a criminal lawyer. I have other friends who can. So if I didn't answer it good enough, message me and I'll answer it. But I'll ask one of my criminal defense lawyer friends. How long would it take a bee to fill a jar of honey? Sometimes they could fill it in a day, Brennan. So if it's a hot and heavy, if the nectar's flow is a lot, if you have a lot of flowers that are all blooming, like the last 2 weeks, now it's raining, so the bees don't go out in the rain. But if we have good nectar flows, they could fill it in a day, that kind of stuff. I was in my beehive on Saturday or recently. I moved a lot of frames, so my bees are filling up the honey. It's kind of slowed down now in my view. My bees are doing fine. I have 1 weak hive out of 5. I don't know what to do with it. Weak means that the queen isn't really laying that well, isn't giving more larvae a brood, not making more bees. Sometimes you remove the queen, kill the queen, and put a new queen in there to try to give that hive better energy and have it live through the winter. I'm not sure what I want to do with that yet. I'm going to watch them. I'm going to probably be in there in the next couple of days, go and look at all my hives again. Did not get stung this time. That was a question before. And I just went with just a hat. So they're all calming down. They're chill with me now, more chill. Let me get another question that I see in my feed here. I think I skipped over one. So let me go up. Excuse me. If someone were to steal your smart device and you were able to track it down online, are you able to go and take it back, or would you need to go through the legal channels? How would this differ if the thief is in a public versus private place like their home? So, I don't know. That's a good one. Davey asks the good questions. So I would go get, look, I mean, what would I do? I'd go get it. I mean, now I'm not going to break into someone's house, but I'd call the police. So did you know, and I'm going to share the article with you. So there was a guy who was stealing beehives. And I'm going to do this. Missouri beehive stealer. And there was a guy, and I'm going to give you this here. I'm going to do this right, and I'm going to put this, I'm going to give you the Columbia Tribune article so I can use a different article. So this guy was stealing beehives and apparently selling them on the internet. And let me go to the bottom of this. Here you go. I'll put up this this article. And a guy who owned a beehive, he put a GPS tracker in his hive, and then the guy stole it because he had some hives stolen. The guy stole it, and then he gave it to the police, and him and the police went and tracked it. So maybe I should, Davey, maybe I should answer the question this way. What I would do is, if your phone or something is stolen and you have Find My iPhone, or you have you have an Android, you have a way to track it, I would go to the police. And if it's someone's house, I'd go to the police and I would go do it. Now, if it's like, if your teenager left it in a house and you know the people, go get it. If it's sitting outside, I'd go get it, but you don't want to have a confrontation. And I mean, these days you never know when anybody has a gun. You never know when anybody's going to be unsafe or do something crazy. So I used to be more about self-help. You know the phrase, possession is 9/10 of the law, right? And then they're going to say that you're not entitled to get it. There's going to be a big fight. I go make a police report, so you set a record for yourself. If there's a police report there and then you're trying to get it, you can say, hey, I filed a police report. I know this is stolen. So file a police report and then tell them you know where it is and go do it. I go do it right away, too, because they're going to turn that off. They're going to wipe that phone. So I think I've answered. Let me catch up to my questions. If you get stopped and a passenger in your car has an open container of alcohol, can you get in trouble as a driver of the vehicle? Yes, you can. You can be arrested for drinking and driving because, David, when you drink and drive, this is a joke, and you're pulled over, what are you going to do? You're going to hand your beer to your buddy and say, listen, you got to follow the SOAR form. You got to take this because I don't want to get arrested. So, yes, you can, because they have probable cause to think that you're violating the open container law. They will BAC you. Certainly, if you have alcohol on board, they're gonna think it's you, and they'll prosecute you for that. And I think they probably should. All right, I'm coming to the end of my time. I don't want to bore anybody. What are my July 4th plans, Adam? I am going to celebrate America. I'm going to wear a red, white, and blue bow tie. I may light off some fireworks. I used to light off a lot of fireworks. I don't do that as much anymore. But I do some. I got a dog that's afraid of them. My old dog that died last summer, my old dog King would go bite these bottle rockets and try to chase them. He loved fireworks, but he's passed. My dog King will be chasing fireworks in heaven in a couple of days. I may go to the parade. I'm going to leave and go to Colorado for a week with my family here in a little bit on July 6th. So I'm going to get ready for that. Take a couple of days break, probably work a little bit. That's it. Everybody, thanks so much for listening to this episode of Lawyer v. Lawyer. Tune in next Wednesday at 3 o'clock. Save your questions. If you have any questions in the next week and want them answered, email me at gary@burgerlaw.com. I just thought of another question I need to answer for next week. A friend of mine asked me, but I won't. I'm going to end this now. You can comment on our web page. You can comment on the feed on this live video. But get your questions to us. We're happy to answer them. Everybody be good. Have a safe and happy July 4th. Celebrate our country. I was just thinking about this. Our country is 244 years old since the Declaration of Independence. Our country is in a strange time. Thanks. Take care. See you next week.